Hi, I'm Fiona McLeay, the Victorian Legal Services Commissioner and the CEO of the Legal Services Board. As a Legal Services Commissioner, it's my job to receive complaints about the conduct of lawyers. Before we begin, I'd like to acknowledge the traditional owners of the land on which we're speaking to you today. For me, that's the Wurundjeri people of the Kulin Nations. Wherever you are watching this video in Australia, you'll be on Aboriginal land as well. I pay my respects to all elders past and present and extend those respects to any Aboriginal people who might be watching this video. As a CEO and Commissioner, I'm passionate about helping people understand their legal rights and become aware of some of the common problems we see. Today, I'm going to chat to my colleague, Rex Punshon, who's one of our senior lawyers and investigators, about what we are seeing in terms of complaints after people have a car accident, or as we call them, a motor vehicle accident, and where things can start to go wrong. The time after you have an accident can be stressful, but it's very important that you understand your rights and the risks associated with so-called free services you may be offered after a motor vehicle accident. At the VLSB&C, we receive quite a lot of complaints about lawyer conduct in these situations. These matters involve services being offered or provided after a motor vehicle accident by businesses like car repairers, hire car providers, towing companies, or claims handlers. Rex has been working on motor vehicle matters for many years, so he knows a lot about the problems people can face in relation to these services. Hi, Rex.
Hi, Fiona.
Rex, perhaps you can start by explaining how these services really work.
Absolutely. So there are certain businesses that claim to offer free or no-cost services to not-at-fault parties involved in a motor vehicle accident. These businesses may target people who don't have car insurance, people who elect not to make a claim with their insurer in order to avoid increasing their premiums, or people who do make a claim but have that claim rejected. And we find that people who speak limited English or who are vulnerable in other ways are particularly at risk in these situations. Mm-hmm. Some people may find these businesses online and others may be referred to them by another business. In our experience, these businesses may tell you that their services are free or at no cost to you because they will recover the cost of their services, whether it's the repairs or hire car, whatever it might be, from the alleged at-fault driver or their insurer. And to that end, you may be asked to sign a form, sometimes called an authority to act or an instructions to act form, which purports to authorise a law practice to pursue the recovery. What you might not be told, though, is that the recovery needs to be made in your name, not in the name of the repairer or hire car provider, because you're responsible for the costs of the services that you're receiving. And that means that there are risks involved in accepting services from one of these businesses.
I know that we often see that people are asked to sign these forms without being told what they mean. And sometimes people mistakenly believe it's a completely different type of form. Can you give us some examples about the kinds of problems that you've seen?
Well, a common problem that we see is that some law practices take significant steps, such as starting court proceedings or accepting settlement offers without the person who signed the form knowing that that has happened or fully understanding the implications. We even see situations where the person who signed the form doesn't know that a lawyer is claiming to act on their behalf. For example, we saw one matter where a person believed that their claim was being handled by their insurer, but later found out that it was being handled by another completely unrelated business. We've also seen situations where people have been told that if they don't allow a lawyer to start court proceedings in their name, then they will have to pay for the cost of the services themselves, despite having initially been told that those services were being provided to them for free or at no cost to them.
That raises issues then about unexpected costs, and that can have a big impact at any time, but particularly in the current economic climate. people might not realise the potential consequences they can face if court proceedings are commenced in their name. Can you talk to us about those risks?
Yeah, well, I think the main risk is that even if you firmly believe that you were not at fault in the accident, court is unpredictable and you can never be guaranteed a successful outcome. If you allow a lawyer to start court action in your name and you end up losing the case, or even if you end up getting less than an offer made by the other party at some point to settle the dispute, then you will probably be ordered to pay the other party's legal costs. And those costs can be quite significant. For example, we've seen a matter where a person was ordered to pay more than $13,000 in legal costs to the other party following an unsuccessful motor vehicle claim. In some situations, one of the businesses involved in the matter may offer to give you an indemnity, which is basically a guarantee that they will cover the other party's legal costs if a costs order is made against you. However, it's important to understand that even if that kind of indemnity is provided, any costs order will still be against you personally. And that means that if the business refuses or fails to honour the indemnity, then unfortunately you could be left on the hook.
So Rex, you talked about authority to act and similar forms. Are they enough for a lawyer to rely on?
It's a good question, and in our view, no, they're not. Our expectation is that if you've signed one of these forms, then the lawyer should communicate with you directly and explain things clearly to you instead of simply relying on the form.
So what sort of communication should people expect if they have signed an authority to act form?
Well, first of all, the lawyer should contact you at the start of the matter, A, to confirm that you have actually signed the form, is your signature, B, to explain their role, and C, to confirm whether you do want to engage the lawyer to act for you. If you say no, then that should be the end of the matter. The lawyer shouldn't take any further steps. On the other hand, if you say yes, then the lawyer should ask you some questions, in particular questions about how the collision occurred and any losses that you've suffered. They should also give you advice about the strength of your claim, any losses that are unlikely to be recoverable, and of course about the risk of being ordered to pay the other party's legal costs. As the matter progresses, the lawyer should keep you up to date, and that should include letting you know about any legal issues that arise, such as the other party disputing the amount of repair or hire car costs that are being claimed on your behalf. Importantly, the lawyer also needs your express approval, what we call your instructions, before taking any significant steps in the matter, such as starting court proceedings or accepting a settlement offer. And if there are particular court forms that you need to sign, then of course the lawyer should explain to you what those forms are. And lastly, while many matters do resolve at some point in the court process, it's possible that your matter could go all the way to a final hearing. If that occurs, then you may need to give evidence in court, and your lawyer should explain to you what that will involve.
While we're talking about communication, I think it's useful for people to know that they might be contacted by a paralegal or a law clerk from a law firm. And while that's fine, they need to clearly identify the name and contact details of your lawyer so you can speak directly to the lawyer.
That's an important point. Another important point is that the lawyer needs to give you information in writing about their costs, including an estimate of the total legal costs if they're likely to exceed $750. And importantly, they need to do that, and they need to make sure that you understand the information, even if they intend to recover their costs from one of the other parties involved in the matter.
So, Rex, lawyers also have obligations about how they manage the money they receive on a client's behalf, don't they?
That's right, Fiona. As you'd know, if a lawyer receives money on your behalf, such as money paid by another party to settle the dispute, that money is usually considered trust money. And there are rules about how lawyers need to deal with trust money. In particular, a lawyer can only pay trust money to a third party if you, as the client, direct the lawyer to do so. And a lawyer can only withdraw trust money to pay for their own legal costs if you have specifically authorised that withdrawal, or if the lawyer has sent you a bill referring to the proposed withdrawal and you don't object to that within a certain time frame. The lawyer also needs to give you a trust account statement showing all of the relevant payments from their trust account, and they need to do that at any stage of the matter if you make a reasonable request and at the end of the matter.
As we mentioned at the start of this video, we receive many complaints in relation to motor vehicle matters. If the issues we've been discussing today have raised any alarm bells for you, or if you're concerned about your lawyer's conduct in your matter, we do recommend that you speak to them as a first step. If you still have concerns, you can contact us using our consumer inquiry form on our website, by emailing us, or calling us. I particularly want to hear from you if a lawyer is claiming to act for you without your agreement, telling you that you must allow them to act for you because you've signed an authority to act or other similar form, or if they have not communicated with you properly. There are a couple of other ways you can protect yourself too. If you're not sure if a lawyer has been engaged by your insurer, you should ask the lawyer and your insurer directly. If you're worried court proceedings have been started in your name, you can contact the Magistrates Court of Victoria and check. Lastly, if you have concerns about the conduct of another business involved in the matter, such as the car repairer or hire car provider, you can speak to a community legal centre to see if you are eligible to use their services. Rex, this has been really helpful. To wrap up, it would be great to know in a recap the key things that people need to know about motor vehicle accidents.
Yeah, I think the key takeaway is that even if one of these businesses tells you that their services are free or at no cost to you, there is still an element of risk for you as the consumer. In particular, you may be asked to start court proceedings in your name. If you say yes to that, then you expose yourself to the risk of being ordered to pay the other party's legal costs. And if you say no, then you may be told that you now need to pay for services that you were initially told would be free. So I think it's important to be aware of those risks when you're weighing up whether to accept services from one of these businesses. As many people would know, if you have car insurance, then you may not need to engage a lawyer to recover compensation for expenses following a car accident, like repair or hire car costs. You may decide, having weighed up the risks, that you're better off making a claim with your insurer.
Thanks, Rex. That's been really helpful. Really appreciate your insights into this important issue.
Thank you very much, Fiona. My pleasure.